The Aurora Colorado shooter and OJ Simpson both in court this week. We're joined by WGY legal analyst Chas Farcher of Martin Harding and Mazzotti. Good morning, Chas.
Good morning, Kelly. Good morning, Chuck.
Hey, Chas.
So let's start with James Holmes, the Aurora Colorado movie theater shooter. What does this not guilty by reason of insanity plea mean?
Kelly, there's an old saying, and it's you have to be crazy to plead insanity, and the reason is that defense almost never works. Just to give you an idea, in this state, we've had 6,000 cases in the last decade where the insanity defense was used. It's resulted in an acquittal about 7 times out of those 6,000. What the defendant's got to show, what his attorneys have got to show, is that he lacked such mental capacity that he actually couldn't understand the consequences of his conduct. In other words, what the result of shooting someone would be, or that he couldn't appreciate that conduct was actually wrong in this society.
So I thought that was interesting. Under Colorado law, that they, we always hear that, you have to know whether the illness prevented you from knowing right from wrong, but also whether he was unable to stop himself due to mental illness.
Yeah, it's such a difficult defense for a couple of reasons. One, jurors are very, very reluctant to buy it, and I think it's probably because of that slippery slope argument. You're acquitting potentially mentally ill people of these horrific crimes. But in a case like this, particularly because of the amount of, it appears, premeditation and pre-planning that went into it, placing the car in a certain place where you could get away, booby trapping the apartment, all of those facts tend to show premeditation or a well thought out plan here.
We are talking to WGY legal analyst Chas Farcher of Martin Harding and Mazzotti. Now let's talk about OJ. OJ's back, and he's trying to get a new trial, this writ of habeas corpus.
Yeah, what here's another one. What OJ's actually doing is what we call in New York State the Hail Mary defense at this point. He's claiming ineffective assistance of counsel. The last lawyer he had, a lot less known from the murder trial, was this recent robbery that he had in 2008. He went to a hotel room, tried to reclaim some of his sports memorabilia, and unfortunately apparently did it by gunpoint, which is robbery and kidnapping. So now he claimed that he lost his last trial in 2008 because his attorney was ineffective. And I think, anyone could make that claim. Obviously, the attorney was ineffective. You lost, and you went to jail.
Yeah. So how does the court, or how do they determine whether an attorney was ineffective, and to what level of ineffectiveness needs to be proven?
Yeah. You have a constitutional right. The Sixth Amendment gives you the constitutional right to counsel, but you don't have the right to the best or the bravest of counsel. In order for the constitutional right to be satisfied, all that has to be shown is that your attorney and your defense was meaningful. And what that means is that the attorney asked questions, attempted to proffer some kind of defense. So it's a very loose standard, and it's not one that rarely ever succeeds as well. If it does, best case scenario for OJ, he'd be looking at a new trial on the charges. What's interesting about this particular defense is not so much the claim that his attorney was ineffective or not helpful to him, but the second half of that claim is that his attorney had an inherent conflict, and that may actually have a chance to succeed.
What was the conflict?
OJ's claiming that he paid his defense attorney $700,000 to defend him, so that's a significant legal fee that the attorney would want. At the same time, he's also claiming that he had spoke to his attorney prior to going to reclaim the sports memorabilia, told him about his plan, and that the attorney advised him he was well within his rights, there was nothing illegal about it. And that's something that OJ could potentially use to combat intent down the road, but you can't call your own attorney as a witness. So therefore, the attorney takes himself out of OJ's defense by representing OJ. So the attorney wants the defense fee, he wants the case, but he has a conflict because he may be a potential witness for OJ's defense.
What attorney would say, yeah, grab a gun, go to a hotel room, hold these people at gunpoint, and get your stuff back? That's great legal advice.
Yeah, that's right. You got it. Maybe a malpractice claim going down the road next.
Or I think someone's lying about it.
Yeah. That's it.
OJ lie, I find that hard to believe.
Jeez. WGY legal analyst Chas Farcher of Martin Harding and Mazzotti, 1-800-LAW-1010. Chas, thank you.
Have a great day, guys.
Take
You
care.
too.